And we're off, but not before a little courtroom tech trouble. Ever notice how a slow computer seems to hit just when things get serious? Even the justice system isn't immune to loading screens.
Good morning. Are you Mark Hebert?
Yes, ma'am.
My computer is going extra slow today.
What is the computer?
Me too, maybe, but the computer is winning on the slow. It's just spinning now.
Busy today.
Huh?
It seems crowded today.
No, it's kind of a smaller docket that we have. Okay, here we go.
Okay, pay close attention here. This isn't your average traffic ticket. We're talking about a third-degree felony DWI, and it's not his first rodeo. Prior convictions. Yep, the court's about to walk a very fine line between accountability and rehabilitation.
And will Mr. Hebert waive the formal reading of the indictment?
Your Honor.
Mr. Hebert, in cause number 250455, you're charged with the third-degree felony offense of driving while intoxicated, third or more, from April 16th of 2024. The indictment alleges you were previously convicted of driving while intoxicated March 31st of 2010, and then after that, January 8th of 2013. And how do you plead to that charge? And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with?
Here's the legal twist, a 5-year prison term, but on paper only. He's getting probation, instead assuming he can follow the rules. Think that's a fair deal? Or did he just dodge a bullet? Let me know in the comments.
Speak up, yes.
Yes, I'm sorry.
And I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you reached is for a 5-year term in prison, but that would be probated for 5 years. You'd be on probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Also, it looks like there would be a dismissal,
Misdemeanor.
a misdemeanor, what kind of case?
It's harassment.
Okay.
I actually have the cause number now.
Judge, if I may hold off on that until sentencing, just so we
Sure.
can check it.
Right.
Yes, sir. Yes, ma'am. Is that your understanding of the agreement?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number
No
1.
objection.
Case reset. That means we're not done yet. A pre-sentence report is like a deep dive into the defendant's life-work history, past behavior, maybe even what kind of cereal he eats. It helps the judge tailor the final sentence. Personalized justice. Anyone.
It's admitted. Is there any evidence that Mr. Hebert's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you at sentencing.
Thank you. Thank you.
Now here's a curveball. Critical video evidence can't be played because it's the wrong format. Seriously, the fate of this case is hanging on a file compatibility issue. Tech hiccups meet courtroom stakes only in modern justice.
Thank you, Judge.
Thank you, Mr. Parker.
You know that I beat Charlie real awesome today.
I don't think he's on the docket.
I know. Tough point.
That did not matter.
I know.
Judge, maybe you're close on that.
Yes. John Van Wright.
How you doing this morning, Judge?
Good, how are you?
I'm doing all right. They said have kids. My kid gave me a hand in the mouth.
Oh,
I was
no.
out for like a week and a half trying to get over that.
Been there, done that. Good morning. Are you John Van Wright? And it looks like there is an MTRP as well as a new case in cause number 242485 and 15-23582. And what is the announcement?
Judge, I'm asking for 30 days only because there's a video that is not formatted correctly, and I'm trying to watch it, and according to the state, it's a pertinent video that I really need to see.
Okay. I'm going to reset it. Make sure you work on that early so that we're not figuring that out on the day of court.
I am, Judge.
Mr. Van Wright, if you'll stay in touch with Mr. Mitchell, once he gets all that worked out, the technology part, you can go in, watch that with him. That way you'll be better equipped to make an announcement at the next court date.
And if I have to, Judge, I'll get Mr. Smith to go watch it in his office if I need to.
Okay, perfect. Thank you. All right, thank you. Mr. Lewis, you have Crystal Vogan. Yes, sir.
On the initial, somebody said they hired right.
Mhm.
Like I said, she hasn't yet. She's supposed to, but she hasn't completely hired.
Ms. Kleinan? Mr. Kimler said that you haven't actually hired him all the way yet.
He told me to bring it to HR.
Okay, I'm going to reset your case one more time. Make sure you take care of everything you're supposed to with him and before that next court date, okay? Step in front of the clerk. She'll give you the reset notice right here. Mr. Kevin Lane on Alexis Bourgeois Cooper. Good morning. Are you Alexis Bourgeois Cooper? And will your client waive the formal reading of the indictment?
She will.
All right, Ms. Bourgeois Cooper, in cause number 241296, you're charged with the state jail felony offense of theft of property from April 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Alexis Cooper just waived her right to appeal. That's no small move. In legal terms, she's trusting the judge with everything from punishment to mercy. Bold or risky, you decide.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 12 months in the state jail prison, which means you're leaving your punishment up to me. I can give you 12 months in the state jail prison. I can give you less. I can give you probation. It all depends on the information I get when we come back for sentencing. You have an absolute right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they found you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and you're leaving it up to me. Do you understand? And as long as I don't give you more than 12 months in state jail prison, you're waiving any right to appeal. You understand that as well. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Ms. Bourgeois Cooper is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get probation to do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lane. He'll present it to me on your behalf when we come back. And as you're leaving the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you.